and I am acting based on those undertakings I made. I felt it my constitutional duty to disobey the orders, the unlawful orders of the Chief Justice, and to fulfill my duty as a member of this quorum to deliver my decision within the 45 days that are required under Article 104. With those remarks, I will now proceed to read, in summary, my consolidated reasoned ruling. The petitioner, or before I go to that, of course, on the directives of the Chief Justice, he ordered that all the microphones be switched off, that this tent should be closed, and I want to thank those who gave me directions to an open entrance. But even with this court being closed, this tent, which we turned into a court being closed, I was ready to read my ruling under the mango tree shade. So with those opening remarks, I want to now proceed with reading my ruling. The petitioner, Kyagulanyi Ssentamu Robert, herein referred to as Kyagulanyi, filed this petition on 19 February 2021, challenging the outcome of the presidential elections that were held on 14th January 2021. He filed the petition against A, the first respondent, Yoweri Museveni, Tibuhaburwa Kaguta, herein referred to as Museveni, who was declared the winner of the 2021 presidential election. Kyagulanyi was aggrieved by the declaration by the Electoral Commission of Yoweri Museveni as having won the 2021 presidential elections. On 1st February 2021, he filed presidential election petition number 1 of 2021, in which he made the following allegations. 1, that the elections was invalid on grounds that it was not conducted in accordance with the principles laid down in the provisions of the Constitution of the Republic of Uganda, the Presidential Elections Act, the Electoral Commission Act, bear with me, other relevant laws, and that the non-compliance affected the results in a substantial manner. 2, that the election was invalid on grounds that offenses under the Presidential Elections Act were committed by the first respondent or with his knowledge and consent or approval, and that the entire electoral process was characterized by security agencies, in brackets UPDF and UPF, committing acts of murder, causing grievous harm, violence, abduction, and intimidation against the petitioner. On 9 February 2021, I joined my colleagues on the quorum hearing presidential election petition number 1 to disallow Kyagulanyi's application, seeking leave to amend his petition to this court, where he had challenged the declaration of Museveni as the validly elected president in the elections that were held on 14th January 2021. I have since had the opportunity to read in draft the majority ruling of this court, giving the reasons why Kyagulanyi's application for amendment was not allowed. With all due respect to my colleagues, I do not agree with some of the reasons for the decision I arrived at with respect to the application for amendment of the petition. I'll begin with the law. I entirely agree with my colleagues that the law governing presidential election petitions in Uganda is found in Article 104 of the Constitution of Uganda, Section 59 of the Presidential Elections Act, and the presidential election (election petition rules made thereunder. Article 104 provides in the relevant part as follows. I will not read it in the interest of time. On the other hand, Section 59 of the Presidential Elections Act also provides for challenging the outcome of the presidential election in similar terms as Article 104 of the Constitution. I have not found it necessary to reproduce it here, with the exception of subsection 111, which provides thus: the Chief Justice shall, in consultation with the Attorney General, make rules providing for the conduct of petitions under this Act. It's clear from the above provisions that both the Constitution and the Presidential Elections Act require the following. One, that a petition challenging the outcome of a presidential election should be filed by any candidate who is aggrieved with the result declared within 15 days from the date the challenged results were announced. In this particular case, the results of the 2020 presidential election were declared by the Electoral Commission on 16th January 2021. Two, that once a petition has been filed, the court should expeditiously inquire into and determine it and give its reasons for its findings not later than 45 days from the date the petition was filed. Three, the Presidential Elections Petition Act gives power to the Chief Justice in consultation with the Attorney General to make rules providing for the conduct of petitions. Turning to this particular application, it's not disputed by all the parties that Kyagulanyi, the petitioner, filed his presidential election petition on 1st February 2021. In their pleadings, some of the respondents contended that Kyagulanyi's petition was bad in law because it was filed after the expiry of 15 days from the date the election results were announced. It's indeed true that 1st February, when the petition was filed, was beyond the 15 days after the declaration of the presidential election results. However, it's also worth noting that the last day of the 15 days fell on a Sunday, which is not a working day. Secondly, the Chief Justice had not yet given directions for the record registry to be open on Saturday and Sunday, as is mandated under Rule 12(2)(c) of the Presidential Election Petition Rules. Nevertheless, in this case, the Chief Justice directed that the filing could be done on a Monday, 1st February 2021, and the petition was accordingly filed in court on that day. During the hearing of the application for amendment, counsel for Kyagulanyi relied on the following provisions of the law stated in the notice of motion. I will not read them. Relying on the provisions, counsel for Kyagulanyi contended that the provisions give power to the court to allow his application. He further relied on the following grounds briefly stated in the same notice of motion. One, that the applicant filed a presidential election petition on 1st February and served it on the respondents. Three, I'm skipping some of that filing of two, that filing of pleadings in the petition was still ongoing. Three, the amendment to the petition is necessary to enable this court to effectively investigate and completely determine all questions involved in the petition. Four, that the respondents shall not be prejudiced by the amendments to the petition. Five, that the proposed amendment to the petition did not raise a distinct cause of action in the place of the original. Six, that both the original petition and the proposed amended petition concern the same claim of right. Seven, that is in the interest of justice, equity, and fairness that the applicant be granted leave to amend his petition. Kyagulanyi's application was further supported by his own affidavit and an affidavit by his advocate, Tuliasema Geoffrey, and two supplementary affidavits sworn by him. In his affidavit of 8th February 2021, Kyagulanyi repeated the grounds in his notice of motion and further deponed as follows, and I've laid out what he said. In the said affidavits, Kyagulanyi deponed as to the reasons why he was seeking an amendment to his petition. The supporting affidavits of his counsel, Tuliasima, also deponed to the same facts and the fact that counsel could not access Kyagulanyi at his home for 10 days after the election results were declared by the Electoral Commission. He relied on the decision of this court in Amama Mbabazi versus Yoweri Kaguta Museveni and two others, where this court allowed the petitioner to amend his petition. He also relied on other decisions of this court, which have. The applicant further relied on Rule 22, 44, 42 and 44 of the Supreme Court rules. I've not found it necessary to reproduce these rules. This is because Rule 21 of the Supreme Court rules provides that they shall apply only to appeals from the Court of Appeal. All the three respondents, Museveni, Electoral Commission, and the Attorney General, strongly opposed this application. Relying entirely on non-Ugandan decisions, the respondents contended that the Constitution does not allow for amendment of an election petition outside the 15 days a petitioner is allowed to file. Secondly, they contended that although the applicant's movements had been restricted for 10 days, he still had access to his lawyers. Thirdly, they contended that Kyagulanyi's restrictions did not affect his ability to instruct his lawyers to prepare and file his petition. Fourthly, they opposed the application on grounds that the amended petition was introducing a new cause of action, that is the alleged lack of qualifications of Museveni, the winner of the elections, to stand for and to be elected as the president of Uganda. I have noted in the majority ruling of this court that they agree with the submissions of the respondents. With all due respect to counsel for the respondents and my colleagues on this quorum, I do not subscribe to the alleged legal position that a presidential election petition cannot be amended after the expiration of 15 days, following the declaration of those results. As I noted earlier, all the respondents conveniently ignored the binding precedent of this court of Amama Mbabazi, where we allowed the petition to be amended. The respondents did not canvass this issue, nor the issue why the court should not follow this earlier precedent. While it is true that Article 104 of the Constitution and Section 59 of the Presidential Election Petition do not expressly provide for amendment of the petition, none of the said provisions expressly bar this court from allowing amendments. In the past, this court has jealously guarded the jurisdiction conferred on it by the Constitution and refused to allow arguments by parties praying to the court to hold that its jurisdiction was ousted. And I give an example of a case where this court declined 201 former employees of 4GS Security Services. This court declined to find that the jurisdiction of the High Court to handle employment matters had been ousted by the Industrial Court, which had not yet been set up for 5.5 years after the law was enacted. If this court declined to do so in a case where the law specifically provided otherwise, I would not subscribe to a view that this court's power to grant leave in proceedings before it could be ousted by a mere deduction that the power to amend is not expressly provided for. This court has always upheld its inherent jurisdiction to do justice to all parties as the circumstances of the case before it would warrant. In summary, I state that that is not one of the reasons I disallowed this application. Thirdly, the applicant also relied on Section 98 and 100 of the Civil Procedure Act, Rule 15 of the Presidential Election Petition Rules, and Order 6, Rules 19 and 20 of the Civil Procedure Rules. With the exception of Section 100, I found the remainder of these provisions applicable. Of particular interest is Order 6, Rule 9 of the Civil Procedure Rules, which specifically vests in this court power to allow a party to alter or amend pleadings, his or her pleadings. The rule provides as follows, and I've quoted it. The rule was applicable to a presidential election petition by virtue of Rule 15 of the Presidential Election Petition Rules, which provide that the Civil Procedure Act and rules made thereunder shall apply to presidential election petitions with such modifications as may be necessary. It's however important to note that while this court had the authority to allow the applicant petitioner to amend his petition. Rule 19 uses the word may, thereby giving the court discretion to grant or not to grant the application to amend. I will now turn to the issue of whether or not the application should not be allowed, because the proposed amendments would be introducing a new cause of action. The respondents contended that the proposed amendments of the petition, which was introducing the issue as to whether or not Museveni had the necessary qualifications provided for under the Constitution to be elected President of Uganda, was introducing a new cause of action after the expiry of the 15 days limitation period for filing a presidential petition. It is trite that the issue of persons who are eligible to stand for election as president is a matter of law. These qualifications are spelled out in Article 102 of the Constitution and repeated in Section 4 of the Presidential Elections Act. Section 102 provides as follows, and I have quoted the article, you can access it. On the other hand, Article 104 gives the right to an aggrieved candidate to petition the Supreme Court on grounds that the person who was declared as the winner of the elections was not validly elected. That being the